A syndication sponsor raising capital for a real estate syndication asks about asset management versus property management. The sponsor is charging an asset management fee, but most of the time is tenant calls, repair approvals, rent collection follow-up, and walking units. Then the sponsor asks, isn't all of this just managing the deal? This is Syndication Attorney Field Notes with Tilden Moschetti. I'm Tilden Moschetti. Today's field note is about that line between asset management and property management and why private placement fee disclosures should keep the asset management fee and the property management fee separate. The short answer is this: property management is about the building. Asset management is about the investment. Property management keeps the building running. Asset management steers the investment vehicle that owns the building. That is the distinction to keep in your head. A sponsor can be very active at the property and still not be doing asset management work. Hard work is not the test. The test is what the work is for. If the task is about tenants, leases, repairs, rent collection, local vendors, or code compliance, that is property management. If the task is about debt, equity, investor reports, distributions, refinance timing, market strategy, or the sale plan, that is asset management. The common sponsor mistake is doing operational work, calling it strategic work. And the fee problem follows from that. Investors look at an asset management fee and expect the sponsor or the GP to be steering the deal. They expect someone to monitor the loan, track the business plan, watch the market, review the property manager, prepare investor reporting, and make decisions about refinance or exit. They are not usually thinking that the asset management fee is paying someone to call the plumber, process a unit turn, or chase late rent. Those are real tasks. They matter. But they are property management tasks. So when a sponsor tries to defend an asset management fee with a list of tenant-level work, the answer may not land well. It can sound like charging an executive-level fee for vendor-level work. That is where the legal frame changes. In a typical real estate syndication, the sponsor or general partner wears the asset management hat. The GP is making decisions for the investment vehicle. The LPs are the investors. That role usually comes with fiduciary duties. In plain English, fiduciary duties mean the GP is expected to act with loyalty and care for the investors. A property manager is different. The property manager is usually a vendor. It may be a third party. It may be an affiliated property manager owned by the same sponsor group. Either way, its main duties usually come from the property management agreement. That is fiduciary duty versus contractual duty. The asset manager is serving the investors and the investment plan. The property manager is serving the building under a contract. That distinction matters in the documents. It matters in the fees. It matters when LPs ask what they paid for. Here is a simple example. Suppose the deal is Oak Street Apartments. The syndication entity owns the property. The sponsor controls the GP. The GP charges a 1.5% asset management fee. The sponsor also owns a separate property management company that charges 5% of collected rent. That structure can be workable. Vertical integration by itself is not the problem. The clean version looks like this. The GP earns the asset management fee for investment level work. It reviews the operating budget. It checks whether the property is hitting the business plan. It monitors the loan maturity. It decides whether the market supports a refinance. It prepares investor reports. It decides when to sell or when not to sell. The property management company earns the property management fee for building level work. It leases units. It handles tenant calls. It collects rent. It schedules repairs. It manages contractors. It deals with local notices and code items. 2 fees, 2 scopes, 2 different jobs. Now look at the paperwork. The private placement memorandum, or PPM, should describe the asset management fee in a way investors can understand. How is it calculated? When is it paid? What work supports it? If the property manager is an affiliate, the PPM should also disclose that relationship. It should explain that the sponsor is hiring a related company. It should describe the property management fee. It should say whether the fee is intended to be market rate. It should explain who can replace the manager if the job is not being done well. Disclosure alone does not make an affiliate conflict disappear. It gives investors the facts. The scope, the pricing, and the approval rights still matter. The separate property management agreement also matters. A handshake between related companies is not much of a structure. A standalone property management agreement can define the manager's authority. How much can the manager spend without approval? How often does it report? What reports go to the GP? What happens if the manager underperforms? That agreement helps show that the PM company is not just the sponsor wearing a second name tag and billing twice. There's also a licensing point to check. In many states, leasing, collecting rent, or managing property for a fee can raise state real estate broker licensing questions. The answer depends on the state and the structure. Do not assume the issue goes away just because the property manager is sponsor-owned. The same is true for outsourcing. Do not assume a third-party manager owes fiduciary duties to the LPs. They usually do not. Their duty is usually contractual. They owe the duties they agreed to in the property management agreement. None of this means a sponsor should never do hands-on work. Early sponsors often do everything. They tour the property. They argue with vendors. They read every invoice. They may even step in when the property manager is weak. That can be part of learning the business. It can also be part of protecting the deal in a tight moment. The issue is not whether the sponsor ever touches operations. The issue is whether the sponsor is using operational busyness to justify an asset management fee. A sponsor who spends all week handling tenant issues may feel productive, but that may also mean no one is watching the debt maturity, the capital plan, the market, or the exit. That is the quiet problem with blurring the roles. The sponsor can end up doing property management badly while not doing asset management at all. So use this test. Before a task, ask, who am I serving right now? If the answer is the tenant, the unit, the vendor, the work order, or the physical building, you are probably in property management. If the answer is the LPs, the capital stack, the loan, the refinance, the distribution plan, or the exit, you are probably in asset management. Approving a roof repair is property management. Deciding whether the roof repair changes the annual budget and the refinance plan is asset management. Handling a tenant complaint is property management. Explaining a change in occupancy, cash flow, and distributions in a quarterly investor update is asset management. That is the line. The final field note is this. Clean sponsors separate the roles in 3 places. First, in how they spend their time. Second, in how they structure the entities. Third, in how they disclose the fees to investors. If you own both the GP and the property manager, the structure should show separate legal entities, distinct scopes of work, and market rate fees. The private placement documents and the property management agreement should tell the same story. Property management protects the building. Asset management protects and grows the investment. When those 2 roles stay separate, the fee story is easier to explain and the sponsor looks more like a real operator.